This week's presentation will be on Chapter 6, Administrative and Special Needs Searches. Some of the reasons for the special needs searches or administrative searches are protecting public safety. Certain government activities are aimed at protecting the public's health, their safety, and their welfare, and they have a long history of regulatory enforcement in this country. Regulatory enforcement is quite different from criminal enforcement. You're not going to have the same type of safeguards that you have against searches when they're administrative or public safety needs. You don't have a right to expectation of privacy when you're selling things to the public. Regulatory enforcement, the usual structure of the Fourth Amendments have been modified to allow for more flexible enforcement of public safety laws. Things like inspecting the meat to make sure that we don't have meat that's going to get people sick, or inspecting chemical plants to make sure they don't blow up and kill people in the plant or in the surrounding areas. An administrative search is a routine inspection of a home or business by governmental authorities responsible for determining compliance with various standards and regulations. It seeks to enforce things like fire, health and safety, and housing codes and licensing provision. The administrative search ordinarily does not result in criminal prosecutions, but can result in civil sanctions quite often, rather large civil sanctions depending on the type of violations that are found. As far as searching your home, anytime you build a house, you're going to have building inspectors come out to make sure there's not shoddy work, the plumbing inspector, the electrical inspector, just make sure your house is safe. You'll also have people searching businesses for fire violations to make sure they've got fire escapes, that not overcrowding, that they've got the proper fire alarms, and other things that will keep the public safe. Special warrant requirements are in place for administrative searches. Administrative searches differ in nature and purpose than criminal searches. Therefore, probable cause standards for administrative search differ in its nature and are less stringent than the standard for criminal searches. Again, we're looking at, for the most part, for the public safety. So you're looking out for the public. You're not looking for a criminal, a single criminal. You're looking to make sure everything's safe. So we don't quite have the same guidelines or same standards that you're going to have to reach. There are exceptions to the administrative search warrants requirements. Warrantless inspections of licensed and closely regulated enterprises are reasonable if 1. A substantial government interest supports the regulatory scheme under which the inspection is made. 2. Warrantless inspections are necessary to further this regulatory scheme. And 3. The regulatory status provides a constitutionally adequate substitute for a warrant by advising the owner of a commercial premise that search is being made pursuant to the law and is properly defined in scope and limited in the discretion of the inspecting officer. This comes out of a Supreme Court decision in the New York versus Berger. If you own a chemical plant, you know that OSHA inspectors are going to come. There are certain regulations before you open the plant. There are certain licenses you need. So it doesn't come as a surprise. Oh my gosh, OSHA just showed up my plant. I don't know what they're doing here. Why are they trying to search? I have a right to privacy. No, you know before you open up a chemical plant that has a potential to be hazardous to the people that were working there and the surrounding community, that there are going to be certain government inspections to make sure that you are in compliance with these government regulations. Texas has several different areas where administrative searches are allowed. One can be found in Texas Government Code regarding the inspection and review of plans for fire and life safety hazards. It says that one of the things that you're going to be looking for: the presence of flammable substances, a dangerous or dilapidated wall, ceiling, or other structural element. Obviously, if a building crouches in, it will hurt a lot of people, or could. Improper electrical components, heating, or other building services could be a fire hazardous. the presence of dangerous chimneys, flue, pipe, main, or stove, or other dangerous wiring. Again, this presents a fire hazard. Dangerous storage, including storage and use of hazardous substances. You don't want hazardous material in in the facility where the public is going to be. Inappropriate means of egress, fire protection, or other fire-related safeguards. Got to make sure that the public can get out. You don't want to chain the emergency exit, as occurred in a nightclub. I can't remember exactly. It was in Delaware, somewhere up in that area of the country, where they had people opening the fire exit to let other people in and not paying the cover charge. So the nightclub owner decided, we'll fix that. We'll chain it shut. And they did. And the band they had some pyrotechnics in part of their act that caught some curtains on the fire. And I believe it was about 70 people that were killed in the fire. This are things that you have fire inspectors to make sure don't happen. Another area where we have administrative inspections falls under the Texas Alcoholic Beverage Code. And Section 101-04 says, by accepting a license or permit, the owner consents to the commission and authorized representatives or peace officers to enter the premise at any time to conduct investigations or inspect the premises for purposes of performing any duty imposed by this code. So anytime you've got a bar or any facility selling alcohol, you can do an inspection on the facility to make sure you're in compliance with the Alcoholic Beverage Code. Now, you're trying to distinguish between a administrative and criminal search sometimes can be very difficult. The lines can be very blurred. Kind of depends on the investigative purposes and the privacy expectations. Any criminal evidence found during a valid administrative search may be seized based on the fact that it's in plain sight because you're lawfully there and you spot the evidence when you're looking in a lawful area. When an administrative search begins to take on characteristics of criminal search, stricter standards are applicable to the criminal search apply. So you can't use the administrative search as a ruse to do a criminal investigation. If your real purpose there is to do a criminal investigation, in a murder case, you would probably be wise not to try to use an administrative bar search to go search for the murder weapon. Probably not going to hold up in court. If these standards are not satisfied, any evidence obtained is inadmissible in the criminal prosecution. So you got to be real careful about it, how you go about these administrative search, not using them as a ruse for a criminal investigation. Okay, there's some court decisions that distinguish between administrative and criminal searches. The one we're going to talk about is C versus the City of Seattle. It's a case out of 1967. And in this case, the Supreme Court condemned the warrantless fire inspection of the defendant's commercial warehouse by stating a businessman, like the occupants of a residence, has a constitutional right to go about his business free from unreasonable official entries upon his private commercial property. They said that they did not imply that business premises may not be reasonably inspected in many more situations in private homes, nor do they question such accepted regulatory techniques as licensing programs which require inspections prior to operating or marketing a product. But any constitutional challenge to such programs can only be resolved, as many have in the past, by a case-by-case basis under the Fourth Amendment standard of reasonableness. So you can't just blanketly search a business anytime. You have to have reasonable expectation. Most cities, their fire inspectors are going to inspect businesses that are open to the public on an annual basis. You're not going to go there every day to do an inspection. Now, if you've got problems during the first inspection, you'll probably give them time to fix the problems, and you will go back and do a second search. But you just don't go search them every day, kind of in a way to harass them. Now, there's the special needs doctrine says an exception to the warrant and probable cause requirements of the Fourth Amendment exist where there are special needs of the government beyond the normal needs of law enforcement. Gathering evidence from crime investigations make the warrant and probable cause requirements impractical. So we have to in the special needs, we got to evaluate the reasonableness. Their expectations are evaluated under the reasonableness clause of the Fourth Amendment. And remember, it doesn't say you'll be free from search without probable cause. It says you'll be free from unreasonable search without probable cause. So the weight of the immediacy of the government interest, the nature of the privacy interest allegedly compromised by the search, and the character of the intrusion imposed by the search, and the efficacy of the search in advancing the government interest. These are all things you're going to have to look at for the totality for a special needs search. And the special needs may justify a warrantless search of a public employee's office by the employee's supervisor. So you don't have the same rights to expectation of privacy if you work in a government business. A lot of times we find this nowadays with employees using their government-owned computers and putting some inappropriate things on those government computers. Well, you don't have a right to privacy with that, the computer that belongs to the government, where they can come in and search to make sure you, for instance, don't have child pornography on your workplace computer. For searches conducted by a public employer, the invasion of the employee's legitimate expectation of privacy must be balanced against the government's need for supervision, control, and efficient operation of the workplace. And again, it's going to be determined on a case-by-case situation. If you've got your own private computer in there, and they may not have as much right to do a special needs search on your own private computer when you're at the workplace. And let's face it, most of y'all have your own private computer when you go to work. It's called your cell phone. Your cell phone has more information on it than than the old computers. First computer I had 16K of memory on it, a tape recorder to store the data. And nothing whatsoever like with the computer you have in your cell phone. Now, would the government be able to search your cell phone if you're at work? Probably not. But again, it's kind of on a case-by-case situation. The government partially paying for it. That may make it allow them to search it. Another type of search would be drug testing. They consider it a special need in public safety to conduct drug tests. People who are at work or in heavily regulated industries have less expectation of privacy. So if you go to work in a chemical plant, you don't have an expectation of privacy for drug tests. You work as a pilot in a commercial airline. Drug testing in the interest of the special needs is different from searches done for the purpose of law enforcement. You're not doing it to arrest the person because they're using drugs. You're doing it for the safety of the public. We're going to test the pilot of the airplane to make sure he's not drunk or not high on drugs so that he doesn't crash the plane and kill people, not to try to arrest him for being intoxicated. Now, if you're on probation or parole, you have a lot less expectation to privacy than most people. Searches of probation or paroles are based on the system's necessity for non-adversarial supervision of their population. Conducting searches is a special need justification under the Fourth Amendment. The warrant requirement is impracticable because this is a regulatory. Remember, you've already been convicted of a crime if you're on probation or parole. So it's not like we're taking someone who we have the expectation of the fact that they were innocent. They've already been proven guilty. So the standard's a little bit different. Probable cause standard for searching is replaced with reasonable grounds standard. So, not nearly the proof needed and the warrants not needed to do the search when you're on probation or parole. Now, what about students in school? Well, elementary and high schools are treated different than colleges. We're looking out at the safety of our high school children. Fourth Amendment applies, but the warrant requirement does not. So you do need some kind of reasonableness. And the way you determine is whether the action was justified at its inception, whether the search was actually conducted was reasonable, related to the scope and circumstances that justify the interference in the first place. Generally, the random, suspicionless drug testing of students, particularly participating in extracurricular activity is allowed. And again, this is, it's not a mandatory program to play sports or to be in the plays or to play in the band or whatever the extracurricular activity is. It's a privilege, not a right, and therefore the drug testing can be allowed. Same with doing searches in the students' lockers and such. And again, this is done by the school administration, not by law enforcement. Now, on the other hand, searches of colleges. The laws on search and seizure in college and university is inconsistent. They're going to depend on a lot of things, whether the search was initiated by the police or college employees. Of course, more often than not, if law enforcement went to try to search your dorm without a warrant, without probable cause, anything they find is going to be excluded because it would be a violation of the right. On the other hand, if your college has a policy where they can do routine inspections of the dorm, and the employee finds marijuana plants growing in there and then reports it to law enforcement could then use that for probable cause to get a search warrant to go in and recover the property. Other things, private universities, they're going to have a lot more leeway than a public university because it's a private business and the employees are not government employees. Another area that we need to look at is border searches. There's no reasonable expectation to privacy when you're coming into this country, or that you're in an area which can be considered a port of entry to the country, which will include things like the driving across the border at the Rio Grande Valley, coming into the airport, getting on a cruise ship. Any of these things are ports of entry into the country. Border searches are not part of maintaining the sovereignty, border searches are part of maintaining the sovereignty of the country by flowing both the flow of people and articles into the country, and they play a vital role in maintaining national security. More invasive searches of people, such as strip searches, body cavity searches, and extended period of detention, require a little bit more than just randomness. It's got to be a reasonable suspicion, although they do not require a warrant. And the border search is not limited to the border itself. You can have border searches, I believe the limit's within 100 miles of the border. So, when you're leaving the U.S. border, coming in, driving up through the valley part of Texas, the Border Patrol can set up sites along the interior of the country and still be considered border searches. Other type special needs searches, again, getting into the airport. Special needs for this is the safety of the people. This all came about really around the 1960s. A lot of people, think of 9/11 as the time when we started all these searches. But in fact, in the 1960s, we had a lot of people hijacking airplanes to fly to Cuba. Why, I don't know. Cuba was a communist country. We couldn't just go there, so they would hijack a plane. They'd fly to Cuba and end up getting arrested by the Cuban officials, and whatever happened to them there, we don't know. So it was considered to be a reasonable search when you got it, before you got on a plane, to keep you from bringing guns on there to hijack the plane to go to Cuba. And of course, this became much more stringent after the 9/11, where the planes were hijacked and used to attack this nation. So when you go to the airport nowadays, it's really stringent. Other type things, public transportation searches. Often when you go into areas to get on public transportation, sometimes you'll go through the same type of metal detectors. Going into courthouses, you'll go through the metal detectors to get inside the courthouse, and this have come about because of some incidences where people have ended up killing people, shooting at judges and such in courthouses. So because of the volatility of court cases, often involving domestic cases involving divorce and child custody. So these are just some of the areas of special needs searches, and there are many others, but these are the ones we're covering. Well, that wraps up this week's presentation. Next week we're going to be looking at Chapter 7, Arrest, Searches Incident to Arrest, and Protective Suites.